Good evening, friends. My today topic is family arrangements in India. Our judiciary and our Indian courts are not strangers to family disputes. Large number of the cases in our Indian courts are pending relating to property disputes amongst family members regarding family property and its partition. Sometimes goodwill prevails by intervention of elders to solve this dispute, and family settlement takes place. And our judiciary too has given helping hand to this settlement by taking a very liberal view with regard to the validity of this settlement, and they are giving legal authenticity to this arrangement of family settlement. The central theme to adopt this approach by our Indian courts is that if by valid consent of parties a matter has been settled, it should not be allowed to be redisturbed by the party to the agreement on baseless, frivolous, or untenable grounds. Court described family arrangement as a transaction between members of the same family for the benefit of the family, so as to preserve the property, peace, and security of the family, avoidance of family dispute and litigation, and for saving the honor of family. Such an arrangement is based on the assumption that there was antecedent title in the parties and agreement acknowledges and defines what title is. Thus, oral partition or family arrangement is an extremely valuable arrangement whereby the peace, happiness, honor, and welfare of the family are secured and litigation is avoided. It is specifically helpful in the case of illiterate members or not well off members of a family or who have no means to bear expenditure of legal process or legal advice. By family arrangements, it is intended to set at rest competing claims or to settle claims finally amongst various members of the family to secure peace, goodwill, harmony, and amity amongst various members of the family. What happens sometimes due to great harmony amongst elders, they distribute property temporarily between them and construct building upon themselves by their own expenditure. But later on, after their death, second generation may not be having same harmony and disputes take place. Again, elders come into play and settle their disputes and harmony is again created. So, if the true character of transaction appears to the courts to be a settlement between several members of the family of their disputes, with each one relinquishing all claims in respect of all property in dispute other than that falling to his share, and recognizing the right of the others as they had previously asserted it to the portion allotted to them, respectively. The court will effectuate it as a family settlement. It will confer a new distinct title on each other that the parties themselves seem to have regarded in the arrangement, and it is held that it is the duty of the courts to uphold and give full effect to such an arrangements. Now coming to one of the judgments, that is S. San Mugam Pillai and others versus K. Shah Mughal Pillai and others. that is of May 4th, 1972. In this case, Honorable Supreme Court held in its para 13 of the judgment that equitable principles such as estoppel, election, family settlement are not merely technical rules of evidence. They have an important purpose to serve in the administration of justice. The ultimate aim of law is to secure justice. In order to render justice between the parties, courts have been liberally relying on these principles. So, family settlement is an important aspect in today's scenario of legal system. They are quite liberal. If the parties are settling their disputes amicably at home, then the courts do not have any objection to that. They stamp that title on the legal side. It is different thing if there is fraud. Then if it is proved that they may not give title as per their family settlement, but if the things are pure, they are giving that. This is all about my topic of today. Thank you for watching. God bless you all.